come in. Okay. Ready? Okay. Good afternoon, everybody. Kind of making a record of this that will be put on our intranet website. So some of this preliminary stuff I have to say, so it goes on the record. So today's date is August 15, 2017. The time is about 3 minutes after 1. This is the first working group of 2017 for the Motor Vehicle Dealer Board and the Auto Industry Division. We're calling this Rule Group 1. This is the initial meeting. We're here today to talk about, look at two rules, one current rule and one perhaps a proposed rule. The current rule is 12.6.1043G, Motor Vehicle Regulation Application Requirements. And the second one is possibly a proposed power sports regulation to sort of mirror the motor V side for application requirements for the power sports side, and that would be, if we move forward with the rule, it would be 12.6.5042B. So because of this, sort of everybody, I think, knows each other, but for the record, I'm just going to go around the room and have everybody introduce themselves and who you represent. We're trying something new this year on this rulemaking, and that is we are inviting the board members to sit in and have limited participation, but to sit in. So we do have one board member that's sitting in today, observing, because ultimately, obviously, you all know that eventually, as we go through rulemaking process, the Motor Vehicle Dealer Board is the ultimate decision maker on what is promulgated and what is not. Okay, so when we get to that person, that he'll introduce himself that way. I'm Bruce Uloff, Director of the Auto Industry Division, and also the Executive Secretary of the Colorado Motor Vehicle Dealer Board.
I'm Bradford Jones, Assistant Attorney General at the Colorado Attorney General's Office, appearing on behalf of the division and the board today.
Randall Cherry, Attorney General's Office.
Leland Beatty, Legal Assistant, Auto Industry Division.
Lucky Higgs, I'm a partner at EKSNH and I sit on the Motor Vehicle Dealer Board.
Jerry Boot, I represent the power sports dealers.
I'm Melanie Condon, and I am with the Colorado Advocates representing the Alliance of Automobile Manufacturers.
Corey Amond, I'm the Deputy Senior Director of Enforcement for the Department of Revenue.
Ron Camerzell, I'm the Senior Director of Enforcement for the Department of Revenue.
Michael Domermuth, outside counsel for CADA.
Frank Agos, Supervisory Investigator, Auto Industry Division.
Gloria Britton, Compliance Investigator, Auto Industry Division.
Chris Hartman, Agent in Charge, Auto Industry Division.
Chris Rouse, Chief of Investigations, Auto Industry Division.
John Opica, I'm one of the Supervisory Investigators with the Auto Industry.
Arlene Tappinen, Minute Recorder, AID.
Thank you all. A discussion of the process. You all but Melody,
Yes.
all but Melody have sat in on one of these before with us, but we're doing things a little differently this year, and that's bringing the board into it too. So the process in a stakeholder meeting is we sort of look at the rule, we dissect the rule, we get input from everybody that wants to give us input. We'll have input verbally today. We may at the end of the meeting ask for something in writing from some of you. If we need to come back, which we probably will, that next meeting is scheduled for the 27th of this month. That's a Thursday, okay? And that meeting will start probably at 9 a.m. if we need to come back and try to kind of finalize the draft of a rule that we think needs to go forward, okay? You get into this compromise situation. What is people willing to compromise and what are people not willing to compromise? Obviously, the division has a stake in this from a consumer protection standpoint, and I have the staff that I have here today are subject matter experts in all of this area, okay? So we will probably have a strong opinion of what needs to go forward. Eventually, we will notice the rule, and then the official, once it's noticed, then the official rulemaking process starts taking place, and that gets back into the board's realm, where the board makes a final. And the board will eventually have a public hearing on this rule, where again everybody has a say in that, and then the board makes that decision. It's kind of a long, lengthy process. Certainly, it can take 90 to 120 days before you ever promulgate a rule. Once it's noticed and the board then takes action, then it goes to the Attorney General's office, and it goes to OLLS, and it goes to DORA, and everybody gets a piece of it before it actually becomes an effective rule. And a lot of things can happen in between all of those kinds of things. So I'm the farthest thing from the expert in the rulemaking process. So I will always be looking to the Attorney General's office, a couple people on my staff, or Mr. Camerzell for his expertise, because he's been through this a lot more times than he wants to acknowledge with marijuana and liquor. So that's sort of the discussion, the process. I always try to talk about the group discussion guidelines. This is recorded. We will put this on our website so anybody can hear this. So I ask for professionalism. I also ask for, if you disagree with somebody, but do it in a professional manner. Remember that your voice is being recorded. The board members, Mr. Higgs is here today, but the rest of the board members will no doubt listen to this recording before they get to the rulemaking hearing phase. So I just ask that you extend courtesy, try not to interrupt people, wait till they finish their point before you make your point. I don't call for a show of hands unless a lot of people want to talk and so on and so forth, and then I'll go around. Everybody's going to get input today that wants input. I can guarantee you that, okay? So I just ask that it is kept professional. Agenda item number 4 is the working group, the meeting scope of it, and it is to review the regulation that I've handed out to you. You should have gotten that last email from Mr. Beebe. That's the current rule as it is at the Secretary of State's office. Okay. So then we have to talk about the scope is what's broken? If something's broken, what needs to go away? What needs to come in? What needs just massage based on, is there anything in Senate Bill 17-240 that changed this regulation? Okay, so we'll try to talk a little bit about that. And currently there is no sister regulation on the power sports side. And that is, most of the time there is a sister regulation. There is not one on this particular one. Why? Don't know. Doesn't really matter. Does there need to be one? And I'm glad that Mr. Boot is here representing the Power Sports Association and to talk about, when we get to that, does there need to be a similar regulation, and if not a similar regulation, some regulation governing this. At the end, we'll take public comments. Anybody in the public that wants to say anything, they can do that, and obviously this is an open meeting. And then, like I said, the second working group is scheduled for August the 24th back here. Any questions on the agenda? Okay. Hearing none, let's just jump into this document and start going through this. Myself and a couple staff members spent some time on this yesterday. Mr. Beebe has spent an enormous amount of time looking at this regulation over the course of the last 10 days. And I know that he will have some verbal input on things that he feels are important. When you look at Senate Bill 240, the question, I guess, that I have, and I don't have a great answer for it, I don't have an opinion right now, is how much of 240 is impacting this regulation. And I guess right off the top of my head, I'm going to say that not a lot. I don't think a lot of 240 impacts this regulation. So I'm just going to say that, and I'm open to change my mind on that. I'm not carved in stone in that in any way, shape, or form. It just appears that as I've went through 240 the last few months, it seems like, I just don't see that that what 240 did impacts this regulation. Now, one of the things that we are having very much difficulty, I bet you are too, Mr. Donald Muth, is 240 is not integrated into the statutory scheme yet. I looked at least as of today's Tuesday, as of Sunday night, if you go to LexisNexis and try to pull up the statutory scheme, the old statutory scheme is still there, and there's a footnote there or a pre-note about 240, and if you click on it, it takes you to 240, but it's not integrated into the scheme, which makes it very difficult when you to do comparisons. It's really, really difficult to do that. So I don't know when they're going to integrate that into the statutory scheme. It could be any day, and hopefully it is today, because I think then these kinds of discussions at least get a little easier. Okay, are you finding that, Mike?
No, I asked Chris when I came in if where the amendment was we were talking about, and I couldn't find it.
Yeah.
So, and I was jumping back and forth between my statute and 240 and trying to make sense of things, and had a lot of difficulty doing that, Bruce.
Okay. So I'm going to look up something here, and so if anybody else has a comment, just jump in right now, but I'm going to look up a statutory thing here. Go ahead.
Yeah, Leland Beebe. I, unfortunately, in order to do what I need to do as an analyst, had to actually create the statute that is not online, okay? And based upon just 240, I didn't try to add the other manufacturers' components. And tentatively, I would say that the piece that we would have to look at with regard to this rule and determine whether it would make a difference would be found in 12.6.115, and it would be then parent 8, parent A, which has to do with the fingerprints, okay? So that could impact this because it's part of a new application process. And then likewise, the other piece that could impact is 12.6.116, parent 2, wait a minute, nope, wrong, parent 6, parent A, and that has to do with the ownership interest changes, okay, which also would have to do with a form of application that the board currently would need to address. So those are the two pieces, I would say.
Yeah.
Okay.
And I think those are relative to this discussion. One of the thing that I was looking up is obviously we all know that a rule has to have, statutory authority. It has to hook to a statute in some way. And the statutory authority for this application requirements, it hooks to 12.6.104.3G, the statute, which has to do with the board prescribes forms. It's a forms. This application requirement hooks to a forms paragraph in the statute. The board can prescribe forms. So getting back to what Mr. Beebe said about the new aspect of fingerprinting in 240 and the new aspect of ownership change by application in 240, those, if it remains here, it has to attach to the forms part of it. So do you move something out of here and move it over, part of it over into the statute and write a new rule underneath that statute? That is a possibility. Here's what I'm going to say up front. This is why I don't think 240 right now impacts this rule, and that is this. We have, for years, the division and the board have not had a rule pursuant to application other than this, and this is a very general rule. And what I'm talking about, very general language in the rule, no specifics. What has happened is the board has, let's take a look at the salesperson application. The board has approved a salesperson application. About 6 years ago, we did a salesperson application change, maybe 7. Went from 1 page to 7 pages. Within that application, there are tons of additional requirements for the applicant to provide. Did it by application, okay? So they did it by establishing, in general terms, not legal terms, guidelines, okay? We have guidelines, the board has guidelines that are not in rule for dealers. If you want to become a new dealer a dealer in this state, the two primary benchmarks is you have to have $100,000 or more in net worth, and you have to have a credit score of 701 or higher. Nowhere will you find that in a rule. That is a board guideline. Now, the beauty of having a board guideline is that it can be changed at any time that the board wants to change it. Sometimes the board struggles with the 701 credit score. Is that too high? When you can purchase a car at much less of a credit score. So the board has talked about lowering that credit score to 680 or something like that. If it's in rule, you have to go through a very detailed process to change that, where if it's in a guideline, the board could decide on, October 1st moving forward from that, the new guideline is 680. So one of the things that the division has not done yet and will not do for a while is we don't know what we don't know about fingerprinting yet. So what happens is we were very much behind the fingerprinting aspect of 240. Think it was the right thing to do. But the law goes into, so the board passes 240 on the last day, the next to the last day of the legislative session, May the 9th. That's when the statute passed, okay? That's when the law passed. Went to the governor's office. I don't know exactly when the governor signed it. I got it here, but in that time frame. The statute becomes effective July 1. So as of July 1, all new applicants, let's just talk about salespeople to start with, all new applicants are subject to fingerprint. Well, under state fiscal rules, we could not order fingerprint equipment until after July 1. We couldn't. There's just no way that we could do that. Okay, number one. Number two is, and Mr. Opeka can give you far better information on this, you have to be accredited, for lack of a better word. That's not the right word. Accredited by CBI and the FBI before you can submit fingerprints. There's an accreditation process that we have to go through. We're in that process sort of right now. CBI will accredit us tomorrow if we need be, but the FBI may take several months. That's what you were told, I think. So there's a process. So we don't know when exactly we're going to kick the football off the tee and say, from this moment on, fingerprint. Okay, we don't know when that is. We'll do our due diligence to do it sooner than later. I thought we might be able to accomplish it September 1. I'm not sure we're going to make that now because of this accreditation thing. I'm thinking more like it may be October 1. So what I'm saying is we don't know what we don't know. Until we get into that, we're not sure exactly what the pitfalls are of writing a rule around fingerprinting. I think Mr. Beebe found that maybe gaming and marijuana don't have strong rule or any rule around that. They do it by guideline. And there's some real advantages to doing it that way, okay? Because once you carve that into a rule, you're stuck with that for a while. And so I am hoping that we do not have to do rulemaking around fingerprinting and around the application process for ownership change. I'm hoping that the board can put down some reasonable guidelines that the division can follow and the industry is okay with. Comments on that?
To give you one more piece of background, if you haven't read the statutory provision for the fingerprinting, it's fairly definitive. It's as definitive as any agency has in statute, because the effort was made to mirror the best out there. And so, I think there's less need than any agency coming on board with a new statute has ever had to add additional bells and whistles. I mean, you should look closely to see if you see places where the statute is silent enough that we need to add regulation to it. That'd be the issue. And, you know, on the other statutory change, comparably, this detailed level that the statute gets to in 240 with regard to this change of ownership application has no precedent I can see in current legislation anywhere else. So there's so much guidance here that, you know, I'd say we have less fear than most agencies would have entering into this kind of rulemaking, and less need to actually have rules at this point for those things.
And I will tell you, I am not opposed to suggesting to the board new rule if there's a need for new rule. If there's not a need for new rule and we can do it some other way, it's just so much cleaner. And I'll go back, and I'm gonna sort of make a political statement, and there can be people in this room that will disagree, but it's my observation in the last 6-8 years across the nation, and certainly in this state, that the legislative bodies are asking for less regulation through rule than more regulation through rule. We get several bills every year that are sort of giving us that push that, you know, review these rules and get rid of the ones that just don't matter anymore, and be careful when you start promulgating new rule, because we're the legislature, we know better, you know, with the statute's sufficient. So that's my one political statement. It just seems like that's the mood of the country, and that's the mood of the state, and that's not a conservative or it's not a Republican or a Democrat. I mean, we have a Republican president that has suspended all rulemaking at the national level, but we have a very strong Democratic governor here that sort of has that same tone, is be careful on rule. So, Mr. Booth.
Funny, Leland, you should bring up those fingerprints. I had a discussion during the process of the bill. My concern was the language read, with the submission of an application. Now I'm looking at page 21 of the bill. This is 8A that you identified, Leland. My problem is you treat power sports and motor vehicle licenses differently. And I believe you also require a separate application unless I've lost my mind. Will you accept a single application for both?
Ms. Bree. Is there more than one
No, it is the same application.
It's the same application, yeah, because my only concern about that was that it says that you have to submit a complete set of fingerprints to the Bureau for any license. So what I was hoping was that you wouldn't run into a situation where somebody has to put in, you know, they get a power sports franchise, or they get a motor vehicle franchise, and they've got to come in and be fingerprinted twice. So that answered my question, whether you accept a single application or not. That resolves it.
And Mr. Boo, we have to be very careful that what we lobbied for was fingerprinting all new applicants. And so anybody that has a license is that word grandfathered in, so to speak. But if they let that license lapse and they apply for a new license, that's a new
different scenario.
And then we have to be cognizant that we're not fingerprinting the same person multiple times over the course of a very short period of time for a change of a license category or something like that. Once we capture that, we have to be cognizant of that.
That's really all I was trying to ask, to see if there needs to be clarified with the guideline.
Just to be clear, are you talking ABC dealer applies for a motor vehicle license and a power sport license at the same time?
I would be more concerned, that's a possibility, but I would be somewhat more concerned if a power sports dealer or a motor vehicle dealer subsequently wanted to, when you get a new franchise, That's where I come into, or will they be filling out a separate application after they have already been licensed in one of the two areas? So let's say they get the license 6 months later for power sports. My question was, of course, are you going to want another set of fingerprints? It's that simple. I mean, that's really all I'm asking.
And I think that may be a policy thing, and that's something we can discuss, but I think it's a situation if somebody applied for it before this law changed and has never submitted a set of fingerprints, I think the division is going to want them to submit it.
I understand this doesn't have retroactivity. I understand that completely.
But it's,
I'm talking about going forward.
I would expect that if somebody's already submitted that, we wouldn't expect them to submit again. But that's going to be more of.
But I'm not so sure, maybe you shouldn't put a line or two in the guidelines, just clarify how you're going to handle that.
I think you're correct.
One thing for this working group to consider is currently FBI does not flag, so when you run through a fingerprint, they do not necessarily flag for repeat offenses. So it's at a point in time. When you clear them through the fingerprint process, they'll return whatever criminal history for that. In the case of CBI at the state level, they'll actually flag that account. So if someone subsequently, let's say they had a clean criminal history and you approve their license, and 2 years down the road they get arrested, you will get a notification on that. But you won't at the federal level for anything that occurs outside of the state of Colorado. So something to think about. You may want to say, if somebody applies for a new license and they haven't been fingerprinted in 5 years, you might want to do it again in that case. But, come up with a clear guideline on that. Now, that being said, FBI is currently pilot testing through the Texas Department of Public Safety the flagging system at the national level. So once that gets pushed out to all the states and nationally, then it will no longer be an issue. But currently today it is.
I think that's an excellent point, and that's where I'm struggling. I think that's what your question is. I'm struggling is what is that gap in time?
Work through the scenarios, yeah.
What's reasonable? I mean, you print somebody and 30 days later they change something, you print them again. That doesn't seem, is that really what we're trying to accomplish? But 3 years later, 5 years later, that may be a totally different set of circumstances, and there may be a need. So.
I didn't realize about the federal side of that.
Yeah,
That's an
they don't-
excellent point.
they don't
That's an
flag
excellent point of time frame.
Okay, any other comments before we, what I thought we would do is we would just go through this regulation, and my staff has looked at this regulation, and we have a little bit of a difference of opinion in a couple areas, but I don't think we're far off of what maybe is broken and what is not broken, what needs to change and what doesn't need to change. So I think we just go through it paragraph by paragraph and look at that and give everybody input on how they see it. And we can certainly take the lead on that. I haven't got a problem with taking the lead on what we think about that. And I don't want to speak for my entire staff. They're here because they're subject matter experts, and so they have an opinion, and I need to hear it, and you need to hear it if there's an issue that they see. So let's just look at the first paragraph. And I know that staff, we hate the last sentence in there. We want to get rid of that totally. We just, I mean, that bites us all the time. We really try to do that. And I will tell you, we do a pretty good job of getting that done. But there are situations that it is just impossible for us to meet that time frame. So then when we don't meet the time frame, what happens? Do they not get a license, or do they get a license without a proper vetting of things type situation? So I have no problem with us having scrutiny by the outside world, but to put it into that thing is, when we have those issues of computer failures, staff turnover, those kinds of things, sometimes that is impossible to adhere to. And I will tell you right now, I think we are doing a pretty good job of that. It's a pretty high percentage, but we want that out of the regulation, so I'll just say that.
Yeah, we don't have a problem with being held accountable, but if somebody turns in an application on the 13th of the month and the board meeting's on the 15th of the month, we've already sent out the board packet to the board members. So then we have to make copies of everything, do it as a handout, because this is saying if it's received prior to the 15th of the month, it'll be at the next board meeting. The 13th is before the 15th. So it's putting an undue burden on us, and I don't want us to rush through anything or put the board in an awkward position of having to read something on the fly. We've never had a problem. I don't think, Mr. Dommermuth, Mr. Abood, I don't think any of your clientele have ever said, you know, I turned that in on the 13th and they still haven't taken it to the board. We do turn it around very quickly, and we don't have a problem being held accountable. It's just, this is a little much.
Chris, this is Mike Dommermuth. And what if the sentence said approved at the next monthly scheduled meeting? So then you would have a full month rather than just 2 days under the scenario you just described.
So if we phrased it in a manner which said at the next monthly board meeting, and they turned it in on the 13th, the next monthly board meeting would be the 15th of that same month?
Not the next monthly. So that if you turn it in on the 13th of August, it would be heard by the next.
So how would you phrase that so it wouldn't be interpreted that if I turned it in on the 13th, I would have an expectation that it would be taken on the 15th of July rather than the 15th of August, I guess would be.
The month following
Yeah.
the date of acceptance of the application.
Yeah, I mean, if we can find some phraseology,
Right.
I mean, we always do our best.
I know you do, and it's usually my clients who are last minute, right? You know, oh my gosh, I'm getting ready to open and I haven't submitted my application yet. What do I need to do? I dread those calls, and I know you guys even dread them more than I do. But yeah, make it clear that it's, if you get it in by the 15th of this month, we will try to get it heard by the next month of board
Something
meeting.
about carrying something over to the subsequent board meeting. Something, you know, something you could put something in front of that.
Yeah.
Well, and if we want to make this clear, I think it needs to be a complete application, because what happens when the dealer drops off the first page of the application and says, I dropped off my application, why aren't you reviewing it at the next meeting? Because
So a completed application received by the 15th of the month will be reviewed for approval at the next monthly. I thought Ron did a good job with it, the language that he used.
Okay, so we'll try and maybe work some of that language.
I think John's point is a good one. It's got to be a completed app.
Yeah.
Because I know they're frequently not.
Yeah, no, I agree.
And that's where we get into a ton of problems when they're not.
That piecemeal.
A pristine application with no red flags of criminal history, financial, those sail through pretty easily, so.
Now, this is also going to impact the fingerprinting process that we've been talking about too, because that's got to be part of the completed application, right?
Yeah.
It's got to be included in the fingerprinting. So we're going to have a fingerprinting station out in the hall.
I'd like to apply for that job. Oh.
Yeah, the fingerprinting, the submission of the fingerprints to us will have to be part of the application process.
Right.
So when, at the front counter, when somebody comes in and has their pristine application, they're gonna get fingerprinted either that day or make an appointment for the next day. They're gonna get fingerprinted right
Right away.
there.
Right.
Somebody from the far outside world, John's working on this from the far outside world, can get fingerprinted at a sheriff's office or a police department and submit those hard copy fingerprints with the application.
Right.
So it's still gonna be an application process, application time.
Okay.
Mr. Cameronzell, does gaming or marijuana, liquor's different because they're a dual licensing authority. Marijuana may be a dual license. Does gaming have a time frame on application processes like this?
No.
So when they drop off an application, it is, generally speaking, and they do a great job over there, we all know that, but it's first in, first out, and it's when they get to it, but they get to it within a couple weeks or 3 weeks or whatever.
Yeah, I mean, they have an internal policy, like on sport licenses, which are the employees that work in the casinos, they try to do what's called 1 hour licensing. That's dependent on the application being complete and getting everything back in a timely fashion. In the case of businesses, it can take 6 to 12 months, 18 months to do one of those. So it just varies on the complexity of the business. So they don't have anything specifically in the rule on that.
So they have internal policy, but not
Yeah.
external rules, so to speak.
Correct.
Okay. Okay. Anything else on paragraph 1 that jumps out at anybody that you like, dislike?
Yeah. This is always a bit of a problem. The word material. What is a material detail? And I'm not prepared to venture into what that is, but it's kind of like if you know it when you see it, kind of a question. And, you know, if I were defining something, I'd want to have that defined, since we end up perhaps being challenged eventually on what was or was not a material detail.
Well, I don't know of any time that we have been challenged on that particular point, and this rule's been here as long as I have.
Okay.
Leland, what item number are you on?
Oh, we're just on number 1 in that very first sentence.
Oh, okay.
Have you got this in front of you?
I've got it on this.
Yeah, it's just number 1. Just number 1 under the regulation.
Would you like an extra copy? We have one.
That would be great.
Here. I need to
Another wrestling essay, word materials.
No, I just need to know.
No, I understand.
What
I'm
people
just
think.
thinking back and.
Yeah.
I was dying for an excuse to step on my foot because it was falling.
It's a material particularly.
Yeah, that was my worry.
I know why Leland's looking at this from a what happens if, but I think what Chris is saying is it's never happened in all the years that we've ever been challenged on that. Now, is that a good enough reason not to look at it? Who knows, you know? Okay. So I'm making a little star by that. Anything else? Does anybody see anything there? Okay. 2, 3, 4, and 5 can kind of be taken all together, and this is something that I think we have some concerns about 2, 3, 4, and 5. At the same time, I'm not sure that we think 2, 3, 4, and 5 are broken. It's this whole thing of how far do you want to go in a rule to talk about all of these entity licensings? How detailed do you want to get in a rule on this? And I don't have a real gut feeling. I know that some staff members, some subject matter experts thinks that this is not broken. Leave it as is. I think there is a staff member or two that thinks this needs a lot more detail. And I'm kind of in the middle of it. I mean, I just don't know. Do you have an opinion, Mr. Dom?
I don't have an opinion, but I'm sitting here looking at these 4 entities, and these are the 4 types of legal entities that might own a dealership in Colorado, and who from these entities is going to be fingerprinted? That's my immediate question. Are you going to fingerprint every stockholder of a company that has 100 stockholders? Are you going to the same can be said for a limited liability company that might have 100 members. Are we going to really fingerprint all 100 members? I don't think that's what the statute was intended to accomplish, and I hope we don't end up there, but...
Me too.
But that's the question of how deep we're going to dig and how far we're going to go. In terms of just providing their proof of their legal existence, which is really what 2 through 5 are designed to accomplish, I don't have a problem with the way they're written. I mean, this is a normal document that if I was doing a transaction with a party, I would require them to produce, to prove that they are a legal entity, or, you know, recognized by some jurisdiction in the United States. So that's my initial thought on it. And I don't know that we have to get into the detail of how deep we're going to go with the fingerprinting, but I just thought I'd put that on the table right now.
I think that's a valid question, a valid point, and do we do it here, or do we do it with a guideline when we lay out the guidelines of fingerprinting, how deep we go? I don't know. Who else?
I can tell you how other divisions handle it. Gaming requires all officers and directors of the entity to be found suitable, which includes fingerprinting. And then they have a trigger, I believe it's 5% or more. Would require a criminal background check. Less than 5, they consider it to be, they have to, a limited owner, and they fill out this little form, but they actually don't fingerprint them. At marijuana, it's very similar. All officers and directors of the entity, and they don't actually have a trigger for less than, so that any owner. Now, understand that they have no publicly traded companies currently. They're prohibited under state statute. So, and up until recently, they didn't have any out-of-state ownership. So they're a little different animal. But certainly you could come up with internal guidelines on what that should look like with industry input.
Officers and directors, is that in rule or is that an internal?
I think they've got in the rule. I think it's in the rule.
Okay.
See, and then the question also becomes, if we're going to put things like that, which may very well be needed in a rule, do we put it in this particular rule, or do we put it in a rule that attaches 116, which is the new fingerprinting requirement?
That's, Chris, I think that would make the most sense. Is that what you're thinking?
Yeah,
too?
I would think it should go with 116, not with the 104 that we're working on here today. But these are fantastic points that we need to make sure that we don't
So Ron,
let slip through.
I'm sorry, Chris, I didn't mean to cut you off. So when you have a limited liability company, is it the managers of a limited liability company that are then, how do you handle partnerships?
I believe limited general partners, not
General
limited.
partners only, not limited?
Yeah.
And then we've got a limited liability partnership, an LLP, so that would be the same thing.
Same
Okay,
thing, yeah.
all right.
So let's, for lack of argument just on this, let's assume that we're going to look at something on the fingerprint side of that issue when we get closer to kicking the football off the tee to fingerprint. If that's where we may head, is 2, 3, 4, and 5 in this current regulation broken or need tweaked? You think it does, I think.
Well, I don't necessarily think it does, but I would add one thing maybe I should have added earlier, which is that in a small survey that I did of sort of application requirements in different agencies around the state, I was surprised to discover that in agencies like banking, where there's an extreme amount of scrutiny paid to individuals entering in, and you know the whole nestedness of corporate interests and things like that, that much of this seems to be done by some kind of internal guideline. And you know, the application requirements merely sound like whatever the board or the division requires. That's what people have to fill out. So it all looks like it's happening in a kind of behind the regulation posture. And, you know, if we went in that direction, things like the enumerations of 2, 3, 4, and 5 wouldn't even be needed, but perhaps a general statement of, you know, following the application requirements of the board would be what you do. I don't know how the AGs would feel about this ultimately, but there's certainly other agencies doing that.
So going back to what I said about the salesperson license, we don't have strong language anywhere in regulation about what a salesperson has to provide an application. It's all on the application that the board, over the course of one long meeting, approved that application. So that makes it a guideline, so to speak.
Yeah. And the other kind of general point is that if you go to Title VII, where you're actually Title VII, Section 90, or 790, and 102, I think. Sorry, I don't have that right in front of me. You see a large number of definitions. And these are definitions that are easily applicable to our agency or to any agency. They're utilized by the Secretary of State's office in the production of requirements related to the submission of documents there. And, you know, that's where you see what's a partnership, what's this, what's that. These are not defined terms for us within our system. But in practice, we have been using those definitions, those requirements of documents that would be considered the right documents to provide us. We've been using that as our own internal guideline. So, you know, it isn't far-fetched to express that if we wanted to in a very general way, not necessarily in a detailed way, just as a thought, you know, just to give a grounding to, you know, everything that we would do in a regulation or do in guidelines. Because we're doing it now. John, I don't know if you can.
Well, I guess the thing to me is I don't necessarily think this is broken. It works just fine. I don't think we're getting any pushback from the industry. The question is really, are they necessary? I mean, does it add anything to have these in the regulation, because we're already asking for more than just what's here?
We're asking for it in the application.
Yes.
Well, and some of them, like on a dealer application, it's not even asked for specifically in the application. It's asked for as part of the background investigation. We need you to provide these documents so that we can give this to the board so they can make a true decision.
But part of that is in a board guideline that the board has approved.
Yes.
Okay. So here again, it's being provided through a guideline.
Yeah.
That the board has approved. Mike, do you see any?
I don't have a strong preference one way or another. My only issue I've ever had with board regs and forms is when they're inconsistent with the statutes. And I don't see that here. I mean, these are consistent with the statutes and the existing regulations. So, you know, whether it's in this rule or not, I don't think it matters. It's nice when I get a call from somebody out of state who is getting ready to buy a dealership in Colorado, if I can send them to sort of a comprehensive place to say, okay, this is everything you're going to need for your application. And then they'll still wait till the day before they're opening.
Well, I mean, I have
Laura's
had.
shaking her head.
But I've had a dealer that I don't want to tell you who our shareholders are. I mean, that's literally something I've gotten, and we don't necessarily have a regulation right now that requires it, but the board's not going to grant a license if they don't know who the owners are. That's just.
It's in subpart 3 now.
Mm-hmm.
Yeah.
So it's there now, John, but.
Well, the article.
Yeah, I'm sure they push back.
Yeah. Yeah, okay, it is there.
Yeah.
Okay, so 2, 3, 4, and 5, for the purpose of, if we need to spend any more time on it, 2, 3, 4, and 5 may not need to be there. If it needs to be there, it could stay as it is. Leland has concerns about definitions of these types of entities and if they should be defined someplace in this rule or in some other manner. Let's move on to 6. 6, I think the note that we made yesterday at our staff meeting is that this probably now needs some scrutiny under 116. Am I right about that? Did I capture that right? Under the new law that says ownership changes by application, not notification, this entire paragraph may need to be looked at under that new statutory scheme. Is that a fair statement?
Yes, sir.
So that 6 may need to come out of this and land over there. Okay.
I don't even know that it needs to land anywhere, because I think it's a little bit better defined in statute
Right.
with the new provisions of 240.
I kind of tend to, I think the legislature, wow, I hate to say this because I'm giving them credit. I just hate to do this. It just pains me. But I think they got the fingerprinting and the ownership, the application, the ownership change thing. In statute, they did a better job than they've done in a long time. So, as far as wording. Okay. Moving forward, 7.
Wait,
Okay, sorry.
Before we leave 6, what about transfers of small percentages? This comes up frequently in my practice where a dealer is transferring shares to his immediate family or to a general manager, executive manager that he or she wants to keep on. So they're going to give an ownership interest to. Are those transfers going to be treated as new applications, or are we going to have a different application form for that that's going to require fingerprinting, et cetera? I heard Ron a minute ago mention a 5% exclusion. Some of the other industries that he works with, I'm wondering if we want to have any discussion of that, or if transfer of even 1% of an ownership interest is going to trigger a requirement for a new application.
Application for ownership change, not application for a new dealership,
Right.
application for ownership change. I think that's a very fair question.
Well, and this is a question that we've talked about a little bit
We did, over
internally,
Department of
and then a
Revenue,
few times with
Right.
the associations. And it's going to make a difference too, which direction that ownership change is happening, you know? If you're giving somebody who's never been an owner before, how much are you giving them that's going to trigger the fingerprinting, versus if Chris and I own a dealership and we're both 50% and we decide she's going to be 80 and I'm going to be 20, do we really have to put in an application for that? We're the same 2 people that have already been checked out.
You've already
But it's a
approved,
change
right.
of more than 5%
To a new person.
in the divvying up. So,
Right.
you know, I mean, I can see if Chris and I own a dealership and we're 50-50 and we decide we're going to add John and we're all going to be 33 and a third. And some.
One of us gets to have
One's
and some.
34. You know, that we're adding a new person, that this new person should be vetted. That was
Right.
the spirit and the intention of everything.
Yeah, and I think I can agree with that, Chris. That, the new person and the sales of 5 or 10% equity to an existing general manager, I don't think are going to be an issue, because that person is most likely already going to have a sales license, right? So they're already going to be vetted by the division, and I think they're going to still have to submit an application, but whether they have to go through the full fingerprinting and vetting again, I don't know.
It's a very good question.
I don't know the answer to that question.
Mike, how do we build common sense into this? Because that's really what we're talking about.
Yeah.
How do we build common sense? Because I know of a franchise dealer in northern Colorado in the next year that the 50%, the 50-50 owners that have been there for a long time are going to stay majority owners, but they're going to transition like 18 and 18% to their sons that are licensed salespeople. I mean, that seems seems ludicrous that we are jumping, we're pole vaulting over something that's a half an inch high, trying to do that. But then on the other side of that is if we have a situation where there's a multiple ownership and that person is coming in from the outside and the red flag goes up when we hear the name.
Right.
We've got to be able to, have that person come in and roll their prints. And so where is that common sense
That's a
then?
really good question.
How do we build common sense into this? Because we really need to try.
And I think Chris raised some good points about, if it's a transfer between an existing already approved licensed member. But one quick question I have on that though, are dealers and salespeople subject to the same licensing scrutiny? Gloria's shaking her head yes on that, for the record. They couldn't hear that, Gloria.
One of the other things that comes up in this type of a thing is, okay, maybe if they're only transferring 3% now and then 6 months another 3%, that 3% can add up over time really
No,
quick.
absolutely.
And the other thing that we see is, kind of like Bruce was talking about, over the next 5 years, I'm going to transfer 30% of this to some other person. So it's not going to all happen at once. There's triggering terms on here. How do we handle that too? Because that's a situation that we can see. And again, concerns that we have to look at is, let's just say that Chris Rouse and I are the 50% owner. I'm the money and she's the knowledge of the industry. Well, if I start giving my portion away to her and eventually back out of it, okay, now we have a business that has no capital because I just walked away. So we have to have some sort of mechanism for addressing those things. And yeah, we need to look at it with common sense, but there's always, common sense isn't very common.
I don't know how you get at the capitalization issue now. I mean, I'm guessing you have thinly capitalized dealerships all over the state currently, John.
Well, we do, and I agree that's tough, but those are things that we need to.
And I'm not sure how you go. I mean, factories, I can tell you on the new car side what happens. On the used car side, it's anybody's guess. But on the new car side, factories have what are called working capital requirements.
Mm-hmm.
And they look at your financial statement every month to see if you are within their working capital requirements. And that's how they make sure their dealers are not thinly capitalized. How that would happen on the used car side, I can't even begin to venture a guess, especially one that would meet Mr. Zulos's requirement of common sense. But, and the point you made about a succession plan where somebody is selling out, 5% this year and 5% next year and eventually going to get up to 50 or more percent. I think that the common sense approach to that would be to vet that person one time at the beginning of the plan transmittal, and then get that person's approved for the subsequent ownership transfers once they survive that initial vetting. I think that would be the common sense approach to that particular problem. But again, I don't know what a threshold limit would be. I mean, I see all sorts of arrangements where people transfer ownership interest, but it's not an active management position. It's truly just an ownership interest in the dealership. That person doesn't have anything to do with the day-to-day operations of that dealership, but they're an owner.
Well, some of the stuff we have to look at as division is a resources thing too. If you've got that succession plan that's taking over 5 years, we have to have somebody paying attention to, did this get fulfilled so that we can change it? So that gets to be resource intensive on our end.
Right. And maybe after that first vetting and approval, then it becomes a notice type situation. That would seem to me to make the most common sense, using that as a touchstone.
I think the ownership change, and don't keep your thought, I think the ownership change where we supported it was from not the internal thing going on. I don't know that we've ever seen a bunch of mischief there. It's that, Mike, you've got all these problems in your background. I'll get the license, and then we'll bring you in the back door and transfer ownership, because all we have to do is write a little letter and we transfer ownership. That's where all the mischief was at, and that's the huge hole we were trying to fill. So I kind of agree that once that's done, maybe then if it's just internally they're just changing percentages, they've already been vetted. So maybe then it is just a notification there.
Right.
I guess the thought I had to add to this discussion is, first of all, I hadn't thought about this, but you can have circumstances that the agency has become aware of that might really signal to investigators the need to look deeper, okay? I mean, we have good investigators, and we have things going on all the time where dealerships are being looked at for this complaint or that complaint, and sometimes the excavation process takes them further afield, and they see more issues. So, you know, it wouldn't be far-fetched to have a threshold percentage or something that would be a triggering point with some kind of a board discretionary exception where if the agency saw something, if the division saw something that might need further inquiry, that it could actually be addressed to the board in the board's discretion whether to ask further. That might be one solution. I'm not saying that's the best solution, but that's the one that just came to my mind to get us to the common sense level where everything's protected. You know, it's not just an arbitrary percentage. It's if there's a need to go deeper, we don't, as a delegated authority, use delegation to do that, or assignment through rule, but we use the process we have right now to work through the executive secretary and bring something forward for the board to decide. That may be a possibility.
Good discussion. We were still on 6, right?
Yeah, and I just brought
Yeah.
this transfer up because, as you know, I did one last year. That was a pretty big one, and I understand that is going away, and we're going to now have new rules on how those transfers occur.
Number 7 probably goes hand in hand with 6, does it not?
Yeah.
Okay. So this is my note from yesterday was this may need to go completely out of this particular regulation and into the statute for the application process or the change of ownership. Did I capture that correctly? So then the issue would be, if we think we may need to do rulemaking on 118, the 118? 116. When do we notice that stakeholder meeting, you know? So, anyway. All right, so 6 and 7, no decisions obviously made today on that, but may need to go away and may need to reappear under 116, or may need to go away and not come back and appear in a board guideline or something. But something, at a minimum, it has to be in a board guideline. Would we all agree? I mean, we just don't think the statute quite gets there. Number 8. My note on this is this works now. Don't change it. Just that's my internal note. Is that correct, staff? Number 9 and number 14 were the subject of some recent staff discussions that led to us asking the AG to weigh in on 9 and 14. We believe, the staff believes that 9 and 14, the way they are currently worded, conflict with each other. And the conflict isn't huge, but it's there. And so if we're going to keep 9 and 14, we need to tweak that just a little bit some way so the conflict isn't there. and give everybody a chance to read those too. And the real issue we had is when somebody does a name change, does that only affect number 9, or does that kick into 14?
When they change the name of their entity.
When they change the name of their entity, because the division has always looked at 14 as a change in an entity, is a change in an entity, is a change in the entity, and requires a new application. In this particular case, we had a manufacturer who also has a dealer's license, drop one word out of the name. And it's a matter of public record now, it's Tesla. Tesla was licensed in Colorado as Tesla Motors Inc. Entity, Tesla Motors Inc., the entity. They nationwide, is my understanding in talking to their corporate counsel, their nationwide is they're dropping the motors out of the name and just calling themselves Tesla Inc., because it fits in with their new business model and so on and so forth, okay? So when we were first contacted, they did they looked at 9 and they did a notification of name change. And we said, whoa, wait a minute here. This is a change of your entity, so it requires a new application. So when I talked to them, talked to their corporate counsel, he said, Bruce, Mike, you've met him, I'm sure. He said, Bruce, look, we're not changing anything in the entity. There's nothing at all changed. It's just the name. There's no operating change, so on and so forth. So then I went back and looked at 9 and I thought, well, okay, I get that. So then I asked the AG to weigh in, and they came back and weighed in, and they think that in this particular case that 9 does apply, and that 14, it's not really an entity change because they really didn't change anything operational. So then they were allowed to change their name simply by using 9, okay? Now, so what happens here is when we get that kind of an opinion for the AG, and they're sitting to my right, and I told them this, okay, if you're gonna give us that opinion, fine, I understand why, but let's not lose sight of where the mischief can happen, because Tesla, there was no mischief in what Tesla was trying to do. You couldn't find anything that there was none. But if you're going to allow it that way, if we're going to allow it that way, where's the mischief if somebody wanted to create mischief? And what I'm talking about there is we've had dealers do this before, where they get into trouble, they get into big trouble, and boom, they're down here changing their name. So they're trying to salvage their business, and they're doing it by changing their name and maybe even moving to a different location. But it's not. They're not changing the entity. They're just running from the problem with the name change. And we've had that happen before. So that's the danger of that. So, comments?
We have also experienced dealerships trying to make it more difficult for someone to sue them by changing their entity name, because then you've got to say all the different names that they've been working under in your caption for your illegal beagles. All the captioning on all your legal cases. And we did have a dealership who did do that on a regular basis.
And one of the other problems we run into is the Secretary of State, if they just do an amendment to their entity name and they keep their ID number, they don't consider it a new entity. It's the same entity. And if you bring it up under one name, both names will show.
I think that's a really important point, Gloria, because, when you think about it, the Colorado Secretary of State's office is a depository of information, but it's also the lead agency for the formulation of the requirements for these things, in a way. So it's the published place for what's a corporation, what's the identity of this corporation, what's the name of this corporation. And so, if they follow the formalities, number one, we could make sure they follow the formalities, if we're going to do anything with them as a start. But if they follow them, don't we need more reason than just suspicion in a general sense for us to ask for more than the Secretary of State's office is asking for? I mean, I appreciate that we get into a lot of trouble around these issues of rapid name changes, but that's a reason to investigate them. But is it a reason for us to say deny a name change? Because they did everything right by the Secretary of State's office.
Well, it's
They're
not a
legal.
question of denying a name change, it's a question of do they need to reapply
Right.
as their new entity. We're
Yeah.
not talking about denying anybody's name change, I just want to make that
Okay.
clear.
I think, I'm going to ask the AG if they have any comment on this, but I think we're about to the point we need to take a 10-minute break or so too. We've been going a little over an hour. And Brad, do you want to weigh in on this in any way? And if you don't, I understand why you don't. I mean,
Well, I think what is apparent to me is the meaning of operating entity, and contemplating defining that in some manner as a potential starting point. Not to say that would be in itself sufficient of a change, but I just wanted to point that out because I know there's been quite a bit of discussion regarding that phrase.
But I guess I have a question is, can the board deny somebody for a name change? Because I don't see in this regulation where they can. And let's say somebody comes up with a really inappropriate name for their dealership. Is there any mechanism to keep that from happening? Other than they may go out of business.
And we have seen that happen before too. We had a dealership on the Western Slope that named it something that was actually an advertising violation because they were, can't remember the exact name, but the implication was you park it here and you sell it yourself from my dealership lot. That was kind of the implication of the name, and I don't remember what it was, but we couldn't stop them from having that name, but using that name on a sign, now that's an advertising violation.
well, hold that thought, John, because I think that we need to talk about that because, I mean, we have Mr. Ehrlich who is weighing in on that very issue about that the board has allowed at least the DBA part of a name to be to immediately be a violation of one of the acts of 126125. I mean, that's really what he was stating that day. So let's take about 10 minutes. Okay, let's come back and kind of get back focused. I think I don't think we'll be here over an hour at all, if that. I think we can get out of here within an hour. Because at the end, I've got a kind of a challenge for everybody. So we were at we were looking at 9 and 14. I think the AG's office indicated they think that operating entity needs more clarification, definition type situation, and that may take care of the entire thing if that is better defined. Let's then back up to number 10. The division's notes are good. We don't think this is broken. It could maybe be worded a little better, but we like the concept here. So the issue of fully, faithfully, truthfully, given fully, faithfully, truthfully, and fairly, those 4 words could be better defined, but the concept of that paragraph we are very happy with. Anybody have any opposition to that? So if we better define those words in some kind of a draft, we'd be okay with, at least in principle, with that.
Is the thought, Bruce, that you want to try to get that to be verified, submitted under penalty of perjury? Is that where you're headed with it?
I don't know that we're headed there, really. It's just that we do use this from time to time. The failure of the applicant, the licensee to so informed, it could be grounds for suspension, revocation, denial. A lot of times we deny because they haven't given us the information correctly, and we've asked for it several times, and they eventually get denied. So I think a rewording of that is something that we think may be necessary, but we think the concept of the paragraph.
It goes far enough.
It's, yeah.
Okay.
Okay.
Does perjury require intent, perjury in the second degree?
Boy, I don't know the answer to that question, Jerry.
I'm just curious, if it requires intent, it's not quite as bad as if it
Yeah.
was sort of a strict liability situation when you're filling out forms. Just curious.
Well, and the way in which we use this is, like Bruce said, if somebody doesn't submit a complete application and we contact them numerous times, please get us this information, this information, this information. There comes a point in time where you have to say, okay, you know, we gotta get the board involved, and they're gonna have to make a denial based on the fact that they don't have full and complete information. So, I mean, that begs the age-old question too of how long is long enough
Right.
to string something out for. We had an employee here several years ago who would let them go for a year, and it's like, no, you can't let this go for a year. So much can change in a year.
Yeah, like net worth.
Yeah, just really, no, you can't keep stringing them along for a year.
So we'll do a little work on that and have a proposal. Number 11, we think that needs to go totally away because it's not needed. I mean, it'll be in the fingerprint part now. Anybody disagree with that?
So in addition to fingerprinting, are you going to require, is the thought to still require disclosure of criminal background?
Oh, yeah, it has to, because the fingerprint, there is a misnomer out there that a fingerprint is the end all, and it's not. My experience in that is, pretty extensive, and you certainly know if it is Bruce Zuloff that you've taken the fingerprint for. I mean, that's where the chances of which we've had in the past, of not knowing exactly who the applicant is. We will know if they have some criminal history when we run that fingerprint. That fingerprint will not give us final dispositions in a lot of things. It will in some. It just depends on how well the local district attorneys in those states enter the final disposition. But a lot of times you just get the true arrest record, so we're going to continue to have to ask for the final court docs.
Well, and the other issue for them disclosing is giving them an opportunity to give rehabilitation information. If you never ask them to disclose it, you're not asking them to give the circumstances and the other stuff that the board really needs to decide whether or not it's important or not.
And I think the fingerprinting will encourage disclosure too.
I hope so.
Start a whole new site business.
I'm not sure I have that much faith, but we.
Okay, number 12, additional places of business. My notes is that we like this. I think we have had some pushback from time to time on this, but I don't know that we have ever, after we have discussed it with the applicant, ever lost that battle. That eventually, after it's explained, it's there. I don't know. And I don't know how often we have had pushback.
Rarely.
Rarely.
Is that enforced verbatim? I was curious because, for example, just take a motorcycle dealer, Fay Myers Motorcycle World West. You don't bother with that kind of thing, do you?
We haven't in the past, but we have had some situations where there's been a major franchise dealership that then had another lot that they called.
Yeah, no, I get it. I
Called
just
something
wondered.
else, where they put the things that weren't good enough to be on their fancy name lot. That's what we want to avoid, not, Fay Myers West versus Fay
No,
Myers
that's the only reason I
East.
asked.
Yeah.
This. Simply because this looks like
Yeah.
it's written like it's verbatim.
It is written like that. So maybe do we need to tweak it? Is that?
Oh, I don't know if you need to tweak it. It just seems like there's a little bit of a, if you're saying it must be the name, which I would go back to the name of record, you know, and then they want to move and open up a new business and they do want to make that different. I don't know that it's a problem. I mean, nobody's raised it. I'm not for fixing anything that hasn't been a problem.
Yeah.
Unless I get a phone call, then I'll call you.
I don't know that it's been a big problem, but, you know, we have a lot of issues, we have a lot of laws and a lot of regulations that haven't been a problem until they're a problem. You know?
Well, and I'm not pushing for any extra work here, just make things clear.
All right, so we'll take a look at that. Number 13, additional places of business carried under a different name, and those are the principal locations must be issued separate licenses, necessitating the filing of a complete application, bond, and fees. I think you and I you had a question on this recently, and because of the way that they wanted to name the business, I said that I thought 13 came into play, and they would need to apply for another license. Is that correct?
This was the rule you referred me to on that issue.
And you totally agreed with me on that, so.
No, I didn't. But I conveyed your position to the client who decided to take the path of least resistance.
Fair enough, sir.
It's worked for as long as it has, Bruce.
Yep.
I'm not complaining.
All right, so 14 we've already talked about. 15,
Could I back up for 1 second
are you backing up to a number?
to 13 for 1 second?
Okay.
We license under a DBA. And so if somebody's changing, wants to have another DBA, they have to have another license. Because that's our standard to license under the DBA, not under the entity. The entity may own completely the DBA, and there may be 5 DBAs owned by that entity, but it's still, each one is going to have a license. And I think that's the consistency, like the reason why that makes sense to keep it as a requirement.
Okay, 14 we talked about. 15. The notes I have is that the division we have no problems with is we're just not sure that this is in the right spot now that we look at it. We're wondering if this should be under the advertising rules. I don't know that I want to open up advertising rules again to insert this, but this may be, I mean, our position is this is a good part of the regulation and needs to be someplace. Not sure why it's in this regulation. Anybody have any issues with that? Okay. I'm not sure where exactly to go now from here. I guess I'd ask Mr. Booth at some point in time to weigh in whether or not this discussion, we need to move when this regulation is tweaked and we get as close to consensus as we can possibly get, should we have a rule very similar to this on the power sports side under the same location where it says the forms issue, which is 126505042B. Do you see any issues with that?
Okay, how are you handling it right now?
Well, there's not a regulation, so there's...
But I mean, you obviously have a process. Are you following this essentially? That's what I'm asking.
That's what we would do, yes.
That's what you would do in this discrepancy. So if you're doing it right now, and I haven't been lynched, I'm assuming that we're okay.
Well, one of the things, and I don't want to paint you into a corner.
But I do want to I would go over this more closely
Sure.
in relationship to.
Here, let me get to the challenge first, and then we'll come back, is that, I think Mike weighed in on this, and he's that we're talking about a lot of things of, okay, is this broke here, or do we need to tweak it, or do we need to just take it out? And we've sort of, in general, we've sort of agreed on most things, but we haven't talked about the actual fixes. So my challenge, especially probably to you, Mike, and to you, Jerry, is can you take a breath here and maybe tomorrow, the next day, look at this and give us something in writing in a real informal way of what you think we should be looking at. What I think we would like to propose for the next meeting is that we meaning the division, draft a proposed rule that encompasses this discussion that we had today, draft a proposed rule, and may encompass what your feedback is. So we get your feedback before we draft that proposed rule. And then when we come back on the 27th, we really get into the nuts and roll our sleeves up and discuss the proposed rule. What do you think about that process?
I think that makes great sense, but one of the things I wondered is the division open to some de minimis transfer, some transfer at some level that isn't going to create a requirement to do a new application? So I think the association would be interested in that. You know, we heard from Ron about this 5% in gaming and marijuana. You know, I don't know if that's something the division is interested in or not.
Well, I can answer from my standpoint, and I would defer to the subject matter experts on this too. The hole we plugged, which I think the new statute plugged, was the hole that I think was really there, was we could have, I hate to say it this way, but it's probably more on the used car side than the new car side.
Right.
We could have nefarious characters come in the back door. Not in the front door, because in the front door you catch them.
Right.
It's in the back door.
Right.
So I think what our proposal was at Sunset, and John worked on that. That was one of John's babies. John worked on that. I think the way it eventually came out in the bill, I think that's the hole we really wanted plugged. Now, the mischief is if you say it's less than 5%, is there a way for that nefarious character, that dealership, to get 5% 1 year and then the next year get another 5%, and all of a sudden they're there and they're in the business, and they shouldn't be in the business for all kinds of reasons. So that's the only caveat to that, Mike.
So, and that could be a rule drafting such as any subsequent transfer that increases the person's interest above 5% of the business would require a full license application.
I think if
Something
you want to
along those
propose
lines.
something like that, I think we would, I mean, personally, I'd be open to something like that.
Okay. Then what about, the other thing that's been kicking around in my head is stock sales and asset sales. Because I work on both of them. I have dealerships that are sold via stock sales and dealerships that are sold via asset sales. And does the division want to treat those the same way for application purposes? In other words, I don't sell you the assets of my business, I sell you the stock of my business. And the corporation, the entity does not change, only the ownership of that entity changes. Asset sales, that's 99% of all dealership transfers are asset sales, and it's only occasionally when Warren Buffett or somebody else, gigantic billionaire, is involved that it's a stock sale.
That's a great question. I don't know.
Yeah, I have some thoughts on it. There's always 100%. Whether it's, I mean, there's a total involved of the assets, or there's a total involved of the stock. And if we're talking about a percentage at the stock level, we could also be talking about a percentage at the dollar asset level. We could. That'd be one thought. The other point is that accounting for that 100%, I think, is essential. That there's nothing left out of, you know, the visible picture that the board would have available if it's going to look at something. So if there's if we're gonna say there's a stock sale, here's your 100%, I don't know what kind of splits, I don't know what kind of other things you might have involved, but in the end, you know, what does that look like? And did this guy over here, or this interest over here, suddenly have an accelerated total comparative to what it had before? Is it now 40% instead of 20%? I mean, I just think we need to see the whole picture, Mike, and then see what the percentage is. And no matter what happens, if there was a notice requirement, an application is different from a notice. If there was an application level, 5% or more, that's one thing. But you could have a notice required for any change. If we had reason to investigate based upon the parties we saw in that notice further, then that could trigger an investigation that might trigger a need for more information. You know, and so there's a threshold, but it's also got some leeway out there. So I don't know if I'm getting across. There's always going to be a notice of some kind. That's what I'm saying. And so the least percentage of change would still get a notice. But the actual application wouldn't happen until a certain level of transfer, dollars, a percentage up in dollars or a percentage up in interest. Does that make any sense? It's just a thought.
I mean, on one hand, I agree with it. Transfer is a transfer. And I think the board should have the right to look at the ownership of the applicant, whether that's a stock sale or a transfer of assets. But again, you know, on one level, I think there should be some de minimis level of transfer that does not create full board scrutiny. It makes Gloria's job easier.
No, it doesn't.
But the other piece I wanted to just throw, you know, again, just to issue spot, not to suggest a resolution, but it's transfers to immediate family members. Whether there ought to be any sort of exclusion for that type of thing. I think the legislature recognized a preference for transfer to immediate family in this area when they passed the right of first refusal statute this year in 298, and that basically said rights of first refusal cannot be enforced on transfers to immediate family members. So, you know, there is clearly a preference for keeping dealerships, keeping Colorado businesses in the hands of Colorado second generation or third generation owners. So, you know, that's something that I think the association would be interested in as well. But I will do my best to get with the association, try to get something back to you guys, and, you know, informal sort of ideas on what we're hoping to accomplish, and try to get that to you in a couple of days.
So today's Tuesday, so Mike and Jerry especially, if you could get us some informal ideas. I mean, we're going to meet again on the 24th. We need at least a full day to draft something. So if you could get us something by close of business even on Monday, the 21st, that gives the subject matter experts in the room, Leland and Chris and John and Chris and Gloria and I, that gives us a couple of days to try to get something into a real rough draft proposal for the next meeting. And what we would like to do then is we would like to blast that out the afternoon of no later than the afternoon of the 23rd. So you've got that to look at for a few hours at least. I mean, we'd like to get it to you a lot earlier than that, but I mean, we'd like to get it out to you 2 or 3 days in advance. But we're on some tight time frames here. This challenge that I'm putting out to you is a tight time frame, and then our turnaround is a tight time frame too, to try to get it done. But obviously, I think the best course of action is when we sit down next time, if we have some kind of a proposed draft to debate, we will be farther ahead.
So we're meeting Thursday the 24th.
24th, yes.
Of August.
Correct.
Not September.
Not September. So when you say get with the
At 1
association,
o'clock?
and no, it's a 9 o'clock.
9 o'clock.
I may back it up till 10, but yeah, it's going to be a morning meeting.
I just hadn't gotten to notice it, I don't think.
Well, it's on the
wasn't
agenda.
calendar.
It's on the agenda.
Oh.
Item 6 on the agenda.
Second working group, yep, sorry, missed it.
And I would just like to add regarding the transfer, in looking in crafting language, I'd encourage you to look at the language in SB 240 regarding 12.6.116, 6A, subsections Roman numeral 1 and 2, which concern the sale and the transfer of ownership. And try to craft language that you think is going to be consistent with that statutory language.
So like I said, I know that we are, this rulemaking thing is just gangbusters. And we try to, I mean, the best case scenario is at the end of the 24th, we have consensus, or as near consensus as we can, where we, within a few days after that, we throw out we notice a rule through the Secretary of State, and then the whole process starts, the formal process starts, but we turn right around and bring everybody back the first board meeting in September, whenever that is, and we're tackling a new group of rules. I mean, it's just one after another right now. It's just. Anything else before the group? With that, hopefully, Jerry and Mike, you can get us something back in a few days. If you have some rough language you'd like us to consider, or ideas you'd like us to consider, and we'll turn that around as soon as possible. And we'll see you back here on the 24th, and we'll obviously leave them a blast email out another notice at that point in time.
Do you want a particular format? You said there was a question about language. Are you looking for specific, actual language?
If you want to get specific, get specific.
Okay, just checking.
Yeah. If not, just in general terms, and we'll take it all into consideration and try to draft something that.
I think the best you're gonna get from me is concepts.
Okay. All right, we're turning off the recording. It's 9 minutes till 3. Thank you all.